Assalamualaikum warahmatullahi wabarakatuh, and good evening to Dr. Farha and fellow friends. We are from SHAHZ and Associates presenting you the case analysis of Syahmie bin Hassan against public prosecutor.
Hi, my name is Muhammad Syahmie bin Muhammad Sahid.
I am Nur Atira Shakira binti Sharoniza.
I am Nur Anissa binti Ahmad Munir.
Firstly, we will look onto the facts of the case. This case is a criminal appeal case. The trial was held at the High Court of Malaya, Ipoh. Afterwards, the appeal trial was then conducted at the Court of Appeal of Putrajaya. The incident of the crime was dated on the 3rd of August 2011. The parties of the case were Syahmie bin Hassan as the appellant and the public prosecutor as the respondent. Judges of the case are Tengku Maimun Tuan Mat, JCA, Ahmadi Asnawi, JCA, and Kamardin Hashim, JCA.
On 3rd August 2011 at 1 p.m., the appellant broke into and ransacked the deceased's house. He stayed there until she returned home at 6 p.m. He also brought a rope to be used against her to stop her from screaming if necessary. When she entered her house, he hid behind a wardrobe and observed her movement. The deceased finally discovered him in her house. She screamed and tried to escape. He jumped on her and tried to strangle her using the rope. She bit off his fingers, causing them to bleed. She then fell and knocked her head against a coffee table, making her unconscious. As she was lying unconscious, he proceeded to strangle her, at first by hand, then using a curtain to ensure her death. He paused to check her heartbeat and hand movement to find out if she was alive. He stopped when he was convinced that she was already dead. He then left her dead body and went back to his house. He came back later and had sexual intercourse with the dead body. According to SP5, one of the appellant's housemate named Nur Hisham bin Shukur, the appellant came home at 8 p.m. and then gave him a gold bracelet for him to sell it. 4th August 2011, 1 a.m. The appellant went inside SP5's room and told him that the bracelet belonged to their lady neighbor and that he had killed her. The appellant then led SP5 to her unit and showed him her dead body. 3 a.m. SP4, a security guard at Permai Lakeview apartment in Ulu Kinta, Ipoh, had seen the appellant walking back and forth in front of Block F of the said apartment complex. SP4 became suspicious and kept his eye on him. SP4 then saw the appellant carrying a rolled-up mattress down the stairs from the first to ground floor. SP4, by now accompanied by his colleague SP3, went to approach the appellant. While on their way, SP3 stopped when someone greeted and talked to him. SP4 continued approaching the appellant and asked what he was carrying. The appellant said that he was taking an unknown woman to a hospital. SP4 noticed that the woman's hand and leg were tied and asked the appellant about it. Upon being further questioned by SP4, the appellant put the mattress down and fled upstairs. SP4 went after him and saw the appellant went inside one of the apartment units at Block F. SP4 left to inform his supervisor, SP2, of what happened. They then inspected the mattress and found the deceased already dead within the rolled-out mattress. The deceased was known to SB4, as about 2 weeks before that, she had made a report about her missing jewelry. SB2 called the police. It was already past 3 a.m. SB6, the appellant's housemate named Calvin Siu, was at a restaurant near the apartment when the appellant suddenly appeared before him. The appellant asked SB6 to send him to a bus station as he wanted to go back to his hometown. Before going to the bus station, the appellant had asked SB6 to fetch SB5. SB6 called SB5 as to his whereabouts. 4 a.m. They reached the bus station. The appellant asked SB6 to buy him a bus ticket to Tanjung Malim, which SB6 did. On the way back from the bus station, SB5 revealed what happened to SB6. SB6 insisted they made a police report, but SB5 refused as he was a military absconder. SB6 then went alone to lodge a police report. At 4:30 p.m., the appellant was arrested at Tanjung Malim.
We shall now move on to legal issues. The first legal issue is whether or not the adverse inference should be invoked against the prosecution for their failure to call Dr. Swaran.
The next legal issue is whether or not the defense of insanity had been proven on the balance of probabilities.
Moving on to relevant law. It is divided between legislation, types of law, and case referred to. Criminality under the Act of a person of unsound mind must be determined by Section 84 of the Penal Code, whereby it must follow legal tests and not merely by the mental state of an accused person according to the medical test. The types of law involved with this case are criminal, procedural, written, national, and common law. Lastly, the case referred to is the case of John Anak kepada Nyumbe against Public Prosecutor. Next is ratio decidendi. To invoke the adverse inference rule under Section 114, subsection 9 of the Evidence Act 1950, there must be a clear case of suppression of evidence. No basis was found to hold that the failure by the prosecution to call Dr. Swaran would amount to an attempt by the prosecution to suppress his evidence. In fact, there was no reason for the prosecution to do so, as his evidence, as pointed out by the learned trial judge, would be in favor of the prosecution.
The next ratio for this case is the whole conduct of the appellant on the day of the incident, from the time he broke into the deceased's house up until his elaborate attempt to clear up the evidence and escape, were patently inconsistent with acts of someone who was mentally unsound and incapable of knowing the nature and consequences of his or her acts. The appellant obviously knew that by breaking into the deceased's house and stealing her valuables, he was committing criminal acts, and as such, he was prepared to silence her from exposing his crime by strangling her. That was his motive. His background of mental illness, slow learning ability, strange behaviors, and depressive modes would not afford sufficient reasons to invalidate his apparently normal mental capacity at the time of committing the crime.
Hence, we were satisfied on the totality of the evidence that at the time of committing the offence, the appellant was not labouring under any form of unsoundness of mind, and he knew that the nature of what he did was against the law. It was in fact a premeditated murder.